All right, Mr. Andrzejewski, tell me what you worked out on position 16 with Ms. Brown.
Okay, on position 16, Judge, on position 16, we don't have a an agreement in the conventional sense. If the court, I understand this is a status calendar, we can't continue this to an in-person trial, but just to give the court a little bit of background on this, Ms. Brown has indicated to me that she has moved out of the property, but has never turned in keys or anything. So I mean, I'd be I'd be open to continuing this case to let her turn in keys, things of that nature, but we would still need a trial on the monetary damages. Or I can go through the filing and ask for a judgment today, whatever the court prefers.
All right, let me speak with Ms. Brown. Ms. Brown, you had an opportunity to speak with the attorney, and it's my understanding you moved out of the property already. Is that correct?
Correct.
When did you move out, ma'am?
February.
February of this year?
Yes.
All right. Did you turn in the keys sent between February and now?
I mean, I wasn't in the state of Georgia until now. So no, I didn't do it.
So, in my opening, I explained that if you still have the keys, you still have possession. And as long as you're in possession of the premises, the landlord can ask for a money judgment for however long you're in possession of the property. Do you understand that?
So I will be in possession of a property if the keys were melted in a fire. So that still doesn't count.
I don't know where that scenario came from, but the reason I go through all that information up front is so you understand what Georgia law says. This is my rule. This is the rule set by
I
the
mean, I know what the law
legislature.
says. I understand what you're
Okay.
saying.
All right.
Don't cut me
So
off.
the attorney is willing to reset the the attorney is willing to reset the case, give you time to turn the keys in, but we will have to have a trial on the money and how much they're asking for as long as you've had the keys.
Okay.
You want to go back and talk to the attorney some more?
No.
All right. So we'll set the case down for trial. Ms. Taquinda Brown, when can you turn in the keys?
I said tomorrow.
Tomorrow being November 21st, by what time?
It'll be in the
All right,
morning when
we'll do close of business. So we'll have you turn in the keys no later than November 21 before 5 p.m. and we'll set the case down for trial on the outstanding money. So I'm going to have Mr. Andrzejewski prepare that order. He's going to email the court. He's going to copy you on the email. Mr. Andrzejewski, anything else on Ms. Taquinda Brown?
No, Judge.
Say my name.
Hold on, Ms. Brown, because whenever you speak out, you're actually talking over me in court. So did you have something you want to say, ma'am?
No.
Okay, so let me, I need to hear from the attorney without interruption. So Mr. Andrzejewski, I'm going to have you prepare that order, email the court, and copy Ms. Brown on the email.
Yes, Judge, I can do that. I do need Ms. Brown's email address. I'm sorry, I didn't get it from her in the breakout room. I got the other two, but
Ms. Hart, do we have Ms. Brown's email address on the answer?
I can look for that, Judge.
Let's look for it on the answer and see if it's in the file. I see an email address at the bottom of her answer.
Okay.
How did we send Ms. Brown the notice of hearing today, Ms. Hart? Well, Ms. Brown, how did you receive the notice? Did you receive an email?
Yeah, I got the email.
All right, and that was the same email that was on the bottom of your answer?
Yeah.
All right, so we're going to send Ms. Brown, use that email, Mr. Andrzejewski, on the bottom
Yes, Judge.
of her answer. Anything else on Ms. Brown?
No, Judge, that's all. That's all I need.
Ms. Brown, you're free to go. You may hit the leave button that appears on your screen. Happy Thanksgiving.